All right, so I'm going to walk through a little bit of legal history and technology as it relates to privacy. And part of the reason I want to do this is that privacy law in the United States has always been fundamentally driven by advances in technology. We'll walk through, starting with the 1890s. Actually, I think starting with the Fourth Amendment, 1791. But we'll walk through primarily from the 1890s to the present some of the major advances in privacy law and the technology that sort of goaded it on, that initiated these advances. As we do this, I want you to recognize that privacy is a derived right, meaning that it is something that we are finding out through the application of law rather than an inherent right, meaning that it is sort of like defined as a right in the law initially. A good example of an inherent right is the right to free speech, right? This is a constitutional right in the United States, and it's sort of saying up front from the very beginning, you have the right to worship where you want, freedom of religion, say what you want in public, that sort of thing. And the government can't hold it against you, except in some very limited circumstances. Privacy isn't like that in the United States. It is with respect to the United Nations. So if you look at the Declaration of Human Rights from the United Nations, they include as a human right privacy. But there is no explicit inherent right to privacy in the United States. Probably the closest that we have is the Fourth Amendment, the text of which, the entire text of which, is right here on the screen. Right. This whole section here. And it's nice to be able to see it all at once and read it all. Key things to recognize is that the right of the people to be secure in their persons, houses, papers, and effects, right? This is a key phrase here. Against unreasonable searches and seizures, which is another really key phrase, should not be violated, and no warrants shall issue, another really critical phrase, but upon probable cause, which this is a really critical phrase in a criminal law context, but we're not really going to get into it in a technology context. The two things that we're really going to focus on is this part and this part, unreasonable searches and seizures. And I'll just start by saying unreasonable here is a really critical piece because in the original formulation from 1791, the government has to be reasonable in what they are searching and seizing, and they have to have a warrant in order to do so. And we'll see how that may change over the course of the development of new technologies. Another critical piece, this is protecting a citizen from the government. It doesn't have anything to say about citizens and citizens or citizens and corporations. It's all about protection from the government because the government has unique powers like the ability to throw you in jail. They have to be constrained in special ways. All right, so let's move on to the right to privacy. This is originally constructed as a Harvard Law Review article. To this day, one of the most widely cited law review articles in history, written by students Samuel Warren and Louis Brandeis. Louis Brandeis eventually became a Supreme Court justice, and we'll hear from him again. The idea here was that they went and attended a wedding, and they saw somebody there taking pictures, and they asked the person what they were taking pictures for, and it turned out they were planning on publishing them in the newspaper, and eventually they did publish them in the newspaper. It was sort of like a high society wedding. And this is sort of like the gossip column of the day, right? You can think of this as like the National Enquirer of the day, publishing front page pictures of some highfalutin wedding that everybody wanted to see and get access to, even though the bride and groom didn't want access provided. So this sort of unauthorized circulation of pictures of private people was the subject of the article. Note that this is not possible just a few years earlier, because a few years earlier in the mid 1800s, people had to sit down and sit still and focus and look at the camera for a good long period of seconds, 30 seconds to a minute or so, to get a picture taken. And now, a new technology, this snap camera that could take an instant picture, allowed for a newspaper photographer to go to a wedding uninvited and just snap a few pictures and publish them. Now, their core argument in the article is that privacy is a right in and of itself, separate from property rights, contract rights, other considerations, that there is actually a right known as the right to privacy. They define it as the right to be let alone. Of course, it's still not fully recognized as the right to be let alone. There are certainly cases where people, even private citizens, can interrupt you, telemarketing calls being a good example. And you don't have a privacy right to sue them, or no private right of action to sue them for that sort of thing. All right, so let's move on to Olmstead versus the United States. This is the late 1920s. This is during the Prohibition era. Roy Olmstead, who was a smuggler, smuggling liquor, and distributing it in the Seattle area, was subject of a federal investigation, and eventually federal agents decided to start tapping the telephone that he was using to receive orders and manage his business. Now, they did this without getting a warrant, and their assertion when the case went to trial was that the Fourth Amendment wasn't violated because they tapped the phone in a location outside of the premises where the business took place, right? So Olmstead owns this warehouse. They have a phone in the warehouse, and the government taps the wires outside of the premises of the warehouse, right, where the wires are going into the warehouse, but not actually on the premises. And they were basically saying that this is because the Fourth Amendment only protects against physical trespass, and that because they weren't trespassing, the wiretapping was legitimate surveillance. And Justice Taft, who wrote, I think, on the majority opinion, if not one of the concurring opinions, that the language of the Fourth Amendment does not extend to the wires that are off premises, outside of the house of the defendant. They're not part of the wires are not part of the house any more than the highways along which they were stretched. And that's basically the precedent that was set by this Olmstead case. Justice Brandeis writes a dissent, sort of a scathing dissent, essentially saying that the Constitution has to be a living document and has to be reinterpreted over time as things change. This, of course, is still a controversial legal position. You've got originalists who would say that's not really a fair way of doing justice, and that it's very hard to have anything like a reasonable set of laws if you just reinterpret the words every single time you want to. But this is the argument that Brandeis is using, essentially saying that papers in the original formulation refer to the things that would be normally have taken place in the 1790s between parties, businesses, and their clients, and that these sorts of communications are now taking place over wires and telephones because it's more convenient, not because they should be protected less in some way. Essentially, Brandeis' argument is that had we had telephones in the 1790s, then telephones would have been added to the list of things enumerated in the Fourth Amendment. And you could also make the argument, going back to the Fourth Amendment, that if you look at this list, that a telephone conversation is just an effect. Maybe that's a fair reading of what Justice Brandeis is saying here. Anyway, the long story short is that he's arguing, but losing the argument, that wiretapping is as much of a breach of security as breaking and entering and seizing papers in the mail. So normally this is the point where I would ask people to think about which argument is more relevant today, and then more importantly, formulate a rationale defending why they think that argument is more relevant today. So I'll just give you a moment to pause the video and truly think up a good rationale before we move on. All right, so moving on, the Katz decision reverses the position that was taken in Olmstead just a little bit less than 40 years earlier. In this case, Charles Katz is a gambling operator, a gambling bookie, who's operating over a phone booth, a public phone booth, taking calls at the phone booth and placing calls at the phone booth to place bets. And so federal agents decided they were going to attach an eavesdropping device, basically a microphone, to the inside of the phone booth where they could listen to the calls. And the Supreme Court rules two things that are kind of critical here. First, that the recordings and oral statements, though they may be intangible items, are actually protected by the Fourth Amendment. They are effects, so to speak. They also rule that the Fourth Amendment protects people rather than places. So if you go all the way back to the Olmstead argument, this house or office and trespass argument is really, really critical to the formulation they have. In Katz, you can't make that because he's operating in a public phone booth. So essentially, they're ruling that the person should be protected rather than the place should be protected from a privacy standpoint. It's worth noting that one of the footnotes in concurring opinion for this argument essentially created the phrase "a reasonable expectation of privacy," and because that was a footnote in a Supreme Court argument, many lower courts have used that phrase, this expectation of privacy, this personal expectation of privacy, and the ways that Katz, who was operating, he closed the phone booth door, that sort of thing, demonstrated that he expected the conversation to be private. A lot of lower courts have used that in the intervening, in the years since, as an important piece of the formulation of whether or not the Fourth Amendment should apply. You could make a reasonable argument that this is kind of unfair because if you go back to the original text of the Fourth Amendment, the reasonability standard is not about the person being reasonable. It is about whether or not the government was being reasonable, right? Unreasonable searches and seizures by the government. So by changing that default position, you've materially changed the way that the Fourth Amendment operates in the United States, all through a footnote in this Supreme Court case. So moving away from telephones and into more broad information practices, in the late 70s, early 80s, it was clear that we needed a new regime, a new way of thinking about privacy for information. And essentially, the fair information practices provide that new regime. And I'm not going to go through each of the individual points here, except to say that broadly, this is the notice and choice regime that we've talked about over the course of the class thus far. So when the Federal Trade Commission enforces notice and choice, essentially they're doing so as a result of the sort of evolution of fair information practices. Basically, that you should provide notice to your consumers, to people who are interacting with your services, of what your practices are, meaning your data collection, your data storage, your data use and retention policies, and then give them a meaningful choice, an opportunity to either take part in the service or to opt out of the service, and go from there. There's a couple of other things that are associated with the Federal Trade Commission's formulation, but the fair information practices serve as the foundation not just for the FTC, but also for European Union data protection agencies and the GDPR as well. So these principles, formulated in the early 80s, late 70s, are actually really critical to the way that we think about privacy in modern contexts. Okay. Another important law that I'll highlight for two reasons is the Telephone Consumer Protection Act. This is mentioned in the textbook in some detail, and I think it's a reasonable example of two things about privacy. The first is that there is a free speech argument in a lot of privacy cases. So, for example, going all the way back to that law review article in the 1890s with Louis Brandeis and the wedding and the photographs. Right? The free speech claim there is these are high society, very important individuals, and so therefore we should be able to publish information about them, even if we're obtaining it from an individual who may not have been invited to the wedding but took the pictures nonetheless. The free speech claim there is pretty strong. And I think today you'd still be able to make those things publishable and publish them in a reputable news source. Even under Prosser's torts, you wouldn't really have a strong protection against that sort of stuff. But in the Telephone Consumer Protection Act, free speech lost, right? So the idea here is that Senator Hollings was really annoyed by phone calls every time he sat down to dinner with his family, and he wanted this private dinner to not be interrupted by these automated marketing calls, and so he decided he was going to write this law and get people to sponsor it and pass it, and eventually it was passed. And that curtails the free speech claims from telephone marketers, right? Telemarketers who are trying to actually get access to the individual in their own homes to exercise their free speech. In this particular case, Hollings is saying that the privacy rights of the person at home should actually have precedence, and the TCPA, because it's narrow in the sense that it really only referring to telemarketers in this one particular case, the claim was actually sustained at the federal level, and this is the current law of the land. And the other reason I wanted to mention this is that this case of Senator Hollings being annoyed by phone calls at his house, that's actually a fairly common way that laws end up getting made. Another good example for privacy folks is the Robert Bork confirmation case to the Supreme Court. A very controversial justice nominated by President Reagan to serve on the Supreme Court. His nomination process did not go well. He was not actually confirmed to the Supreme Court, and part of the reason for that was they brought out his video rental records, and he was looking at some somewhat risque films in the mid-'80s, and that this kind of sunk his chances. As soon as all the senators and congressmen saw just how devastating this was, they decided to pass a law protecting video rental records. So right now, today, in modern United States, your video rental records are given more protection than things like your emails, which are governed by the Electronic Communications Protection Act in 1986. Yeah, it is what it is. But the only reason it is that way is that some people who were in a position of power saw just how devastating it could be to one of their colleagues and took action. Okay, so in the next section, we'll talk a little bit about healthcare and ethics and how they affect privacy.